Representative Niski. Here. Representative Dunwell. Here. Representative Fett.
Here.
Representative Representative Kenseth.
Present.
Representative Norman. Here. Representative Wilson. Here. Representative Ramirez.
Here.
Representative Shigley. Excuse me, to rise. No.
No.
Representative Srinivas.
Here.
Representative Stone. Here. Representative N. Thompson. Here. Representative T. Thompson. Here. Representative Watkins. Here. Representative Wilson Michelle.
Here.
Representative Willard. Here. Representative Woodall.
Here.
Representative Williams. Here. Representative J. Wills. Here.
If there are no objections, I would move approval of those minutes. So ordered. The following bills have been electronically assigned. House Study Bill 118, Representative Lawler, Chair, Representative Wheeler and Wilburn. That was reassigned to Representative Williams, Chair, Representative Stone and Wilburn. House Study Bill 722, Holt, Chair, Gustav and Olson. House Study Bill 723, Lawler, Chair, Stone and Windall. House Study Bill 724, Gustav, Chair, Watkins and Bagneski. House Study Bill 726, Fett, Chair, Stone and Wilburn. House File 2287, Representative C. Thompson, Chair, Representatives Williams and Ramirez. House File 2289, C. Thompson, Chair, M. Thompson and Ramirez. House File 2309, C. Thompson, Chair, Fett and Srinivas. House File 2332, Dunwell, Chair, Fett and Russell Chrisell. House File 2333, Fett, Chair, Stone and Wilburn. House File 2377, C. Thompson, Chair, Wills and Wickendall. House File 2413, Lawler, Chair, Wills and Bagneski. At this time, if there are no objections, I will turn the chair over to Representative Lawler.
Chair recognizes Representative Holt for opening comments on House Study Bill 666.
Thank you. I think all of us were horrified by the video of the young Ukrainian refugee murdered on the subway in Charlotte by an individual who had a long criminal history. So long, in fact, that it left many of us scratching our heads wondering why this individual was ever let out of prison. Had that individual been behind bars where he belonged, Irina Zarutska would be alive today. Instead, she had her throat cut on a subway. None of us want this to happen to someone in Iowa. And after speaking to county attorneys and law enforcement, I found out that unfortunately, we do have a revolving door problem in Iowa. I was provided with several examples of cases in Iowa in which individuals with long criminal histories, after more than a decade, end up committing manslaughter, lives lost because career criminals were out on our streets. This is why we have introduced this legislation. The bill creates real and meaningful consequences for habitual offenders, which will make our communities safer. The bill strikes the current language regarding habitual offenders and replaces it with a system that will ensure that for those who demonstrate through their continued lawless actions that they are not willing to be rehabilitated, will not see the outside of a prison for a long time to come. So here is how it will work. The legislation creates a point system that will determine if an individual meets the newly established requirements for being an habitual offender. It defines habitual offender as any person convicted of an offense who has previously accumulated 3 or more points from any combination of prior level 1 and level 2 convictions. Level 1 offenses are the most serious: Class A, B, C, and D felonies, aggravated misdemeanors that involve sexual abuse, domestic abuse, assault with intent to inflict a serious injury, or while using or displaying a dangerous weapon. Also organized retail theft and possession of a controlled substance. Now, each of these level 1 offenses would carry a weight of 1 point for each conviction. The bill goes on to define level 2 offenses as all aggravated misdemeanors that are not classified as level 1 offenses, serious misdemeanors that involve assault causing bodily injury or mental illness, domestic abuse, assault causing bodily injury or mental illness, harassment, unlawful possession of a controlled substance, theft in the 4th degree, and criminal mischief in the 3rd degree. Now, each conviction of a level 2 offense is worth 1/2 of a point. Remembering that we defined an habitual offender as any person who convicted of an offense who has previously accumulated 3 or more points from any combination of prior level 1 and 2 convictions, that individual upon conviction will serve a minimum term of 20 years in prison unless the current level 1 offense the person is convicted of would carry a higher minimum sentence, which would then be considered the minimum sentence under the bill. This means an habitual offender is going to prison for a minimum of 20 years. Our communities will be safer, and the justice deserved by victims of crime will actually come to fruition. I believe that lives will be saved and our communities will be safer by this approach to incarcerating individuals who refuse to be rehabilitated. Mr. Chair, there is an amendment.
Chair recognizes Representative Holt for opening comments on Amendment 2398.
Thank you, Mr. Chair. The amendment clarifies the language that the three-strike system includes out-of-state convictions. I would also add at this point that before this legislation comes to the floor, discussions will be ongoing regarding a possible language change to clarify that the three strikes applies to separate acts and not a one-day crime spree. We will also be discussing with county attorneys and other stakeholders additional changes that might be needed to include removal or additions to the designated crimes that would be covered under the three strikes provisions. I welcome conversations with my Democrat counterparts on their concerns and how we might improve this legislation. It is a work in progress, but the primary objective of getting career criminals off our streets will not change. This concludes my remarks on the amendment.
Is there discussion on the amendment? Chair recognizes Representative Wilbur.
Thanks, Mr. Chair, and thank you, Representative Holt, for openness, as usual, to ongoing conversations about legislation that comes forward, whether we agree or disagree on those. I don't think there's anyone around the table who doesn't want to see someone, in your words from the other day, Representative, those who are unwilling to be rehabilitated that commits a horrific crime like this. I believe it's our obligation as a state to also look at the entire system of justice, whether it's, is this a court issue? Is this a parole issue? Is it, what is leading to those individual instances, which again are horrific? We also have to take into consideration the effect on our courts, our court system. I'll reserve some other comments about this, but for now, I'll go ahead and support this for the clarification and with the understanding of ongoing discussions, and I'll reserve the rest of my comments for a little later on today. Thank you.
Is there further discussion? Seeing none, the chair recognizes Representative Holt for closing remarks. Representative Holt moves Amendment 2398 short form. All those in favor say aye. Aye. All those opposed say nay. The amendment passes. We're now back on House Study Bill 666 as amended. Is there another amendment? Chair recognizes Representative Wilburn for opening comments on Amendment 2548.
Thank you, Mr. Chair. In my previous comments on the last amendment, I talked about the looking at the entire court system, and we've already heard and seen information data that our recidivism rate overall is down at a 10-year low. And I raised the question about, is this an issue with parole? Is our parole system jammed up? Are they having courts? Our prisons are overcrowded, and so are they feeling a need to get people released, even having the time to review these because they get stacks of these. We have so many people incarcerated now when different individuals come up for parole considerations. There's a particular stack. What this amendment would do would to prior to that third conviction, the court would have in other words, the third strike, the court would have the discretion to reject a prior conviction that were for non-violent offenses. And again, we're looking at the worst of the worst with the overall intent of the bill. And so this creates that opportunity that if someone did have one of the level 1 felonies before, if they accumulate several non-violent, say drug offenses, then an opportunity the judge can remove that. Open any questions.
Is there discussion? Representative Holt.
Thank you. I do take note that you do say for nonviolent offenses, so I do think this is something we can discuss. Unfortunately, because I just got the amendment a couple minutes ago, we're going to need time to evaluate and discuss it. So at this time, I would recommend my caucus vote no, but again, we need to have discussions on this. Okay, thank you.
Chair recognizes Representative Wilburn for closing remarks.
Short form.
Representative Wilburn moves Amendment 2548, short form. All those in favor say aye. Aye. All those opposed say nay. Nay. The amendment fails. We are now back on House Study Bill 666 as amended. Is there further discussion? Representative Wilburn.
Some folks may be familiar with the California 3 strikes, which they did have to, by proposition, was amended. Just so that you're all aware going into this discussion, the impact on the courts in California, the law led to more jury trials and fewer guilty pleas initially, clogged up the courts. That's from the American Bar Association. There have been mixed results and studies on the effectiveness, if it is going after Representative Holt's words, the worst of the worst. Some studies have shown that it hasn't significantly impacted crime rates or other factors like drug policy that may be more effective at reducing violence, while others highlight financial costs for the state. And again, we do have overcrowding in our system here. Some folks have a different opinion on this, but in California, they found that the law disproportionately affected minority communities, contributing to its critique and overall reform. So I asking for a minority impact statement on this one before it hits the floor. So again, the intent to go after the worst of the worst, I think we always have to be mindful of unintended consequences. And since we are going to have further discussions, and I have overall concerns about our overall cost and effectiveness, and want to make sure that our judges have an ability to try and mitigate some of the challenges that came up in California. So I will be a no at this time and look forward to further discussions.
Chair recognizes Representative Holt for closing remarks.
Thank you. Thank you for the good discussion. One of the things I'm concerned about is how crime impacts everyone, especially low-income communities. So we also have to bear that in mind, how crime impacts minorities and low-income communities. And so I think that will make those communities safer as well, or this proposed legislation would. I want to cover, before I close to a vote, I want to cover a couple of examples of the revolving door that we have. And I'm not going to mention the individuals' names. I'd be glad to share them with the committee members. They're a matter of public record, but I just choose not to use the individual's name. I just want to go over 2 cases. This individual had a 20-year sentence and only served a little more than 1 year in prison. He started in 2008, convicted of theft in the 2nd degree. 2010, convicted of burglary in the 3rd degree. That was 2 years later. 2022, 12 years, committed theft. Then it begins. 2023, less than a year later, committed forgery and theft. 2023, 1 month later, convicted of theft in the 2nd degree, sentenced to 5 years. Theft in the 4th degree, 60 days. Felony suspended and placed on probation. 9/28/23, committed burglary, assault, and weapons offenses. 1/18/24, committed delivery of methamphetamine and introducing contraband. Goes on. 2024, convicted of 2 counts of forgery. August 2024, convicted of conspiracy to deliver methamphetamine. Convicted of burglary in the 3rd degree. Probation revoked and sentenced to prison in November of 2024. And then in October of 2025, paroled on all offenses. He spent less than a year in jail for a decades-long crime spree. And here's the one that really concerns me. Crime spree began in 2017. Wapello County committed multiple meth delivery offenses. 2018, convicted of 2 counts of delivery of methamphetamine, receiving 2 10-year sentences. 11/5/2018, sentenced to prison for 20 years after probation violations. 5/23/2019, placed on parole after serving 9 months between jail credit and prison time. 7/31/20, commits meth delivery and involuntary manslaughter. Now somebody's dead. 2020, committed multiple meth delivery offenses. 2021, convicted of delivery of meth. And I'm sitting there going, wait a minute, he was convicted of involuntary manslaughter in 2020, but he's obviously still out on the street in 2021, continuing to do drug offenses. Finally, sentenced to prison in August of 2021, but he's convicted of another methamphetamine charge. And then in 2025, he's paroled on all offenses. His total jail credit before entering prison was 82 days. After being sent to prison on the involuntary manslaughter and meth charges, he served 3 years and 10 months before being paroled. His total incarceration time on a 35-year sentence for 5 felonies was about 4 years and 7 months. This is what we're talking about, and this is what we hope to address with this legislation. Mr. Chair, I move the bill.
Representative Holt moves House Study Bill 666 is amended. The clerk will call the roll.
Representative Holt. Representative Lawler. Representative Wilburn.
No.
Representative Vigniski. Representative Dunwell. Representative Fett. Representative Gestoff. Representative Nordman. Representative Olson. Representative Ramirez. Representative Shipley. Representative Srinivas. Representative Stone. Representative M. Thompson. Representative C. Thompson. Representative Watkins. Representative Wessel Chrisell. Representative Wheeler. Representative Wickendahl. Representative Williams. Representative J. Wells. With a vote of 14-7, it passes.
Vote is 14 ayes and 7 nays. House Study Bill 666 is amended, moves to the House floor as a committee bill. Chair recognizes Representative Holt for opening comments on House Study Bill 664.
Thank you, Mr. Chair. House Study Bill 664 prohibits cities and local governments from enacting any ordinance or other law which is broader or has different categories of unfair or discriminatory practices than those provided in the Iowa Civil Rights Act. This concludes my opening comments.
Is there discussion? Chair recognizes Representative Wilburn.
Thank you, Mr. Chair. I do not support this particular piece of legislation. I think that while there has been an effort to reduce and successfully reduce protected classes in the Iowa Civil Rights Code, there's still some debate about federal law and what may or may not be considered discrimination. I think at the local level, in terms of potential discriminatory actions in housing and credit and hiring, that if there's a category at the local level that's not now at the state level a protected classification, there's no discrimination of someone based on that particular category. If it happens to be gender identity, if someone is denied housing or credit because of gender identity, if it's not in code, then they were just another person who was denied credit, denied housing, denied a job. And so I think it's important at the local level. With this particular issue, that it's important for cities to have the ability to determine what is safe, what they want to monitor. We had real examples of not just on these particular classifications, but people being denied the ability to rate or to rent, or the with housing vouchers, that type of thing. So I recommend a no, and that we get on to some other things related to businesses, jobs, healthcare, et cetera, et cetera.
Chair recognizes Representative Holt for closing remarks.
Thank you, Mr. Chair. I think this legislation is important to prevent a patchwork of different civil rights requirements across multiple local government jurisdictions. And with that, I move the bill.
Representative Holt moves House Study Bill 664. The clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Representative Wilburn.
No.
Representative Vigniski. No. Representative Dunwell. Representative Fett. Representative Gustav. Representative Nordman. Representative Olson. Representative Ramirez. Representative Shipley. Representative Srinivas. Representative Stone. Representative M. Thompson. Representative C. Thompson. Representative Watkins. Representative Wessel Chriselle. Representative Wheeler. Representative Wickendahl. Representative Williams. Representative J. Wells. The vote of 14-7, this passes.
Vote of 14 ayes and 7 nays. House Study Bill 664 is approved and moves to the House floor as a committee bill. The chair turns the chair back to the committee chair.
Thank you. The chair recognizes Representative Dunwell for opening remarks on House Study Bill 669.
Thank you, Mr. Chair. House Study Bill 669 establishes that certain actions taken by parents, guardians, or other individuals to raise, guide, or instruct a child consistent with the child's sex do not constitute child abuse or endangerment. It extends this principle to decisions in foster care, licensing, adoption considerations, and child custody terminations during the ending of a marriage proceedings. Specific actions protected under the bill include referring to a child by titles or pronouns consistent with the child's sex, seeking and consenting to mental health services to help the child live consistent with their sex, making mental health or medical decisions based on the child's sex, and declining consent to gender transition activities as described in Iowa Code Section 147.164. These provisions appear consistently across the bill's amendments, ensuring uniformity in application. Thus concludes my opening remarks.
Is there discussion? Chair recognizes Representative Wickendahl.
Thank you, Mr. Chair. I appreciate the opportunity being given to speak on this bill here today. As one might imagine, I do have quite some passions on that. That being said, I'm going to set those passions aside to kind of dig into this bill and the harms that it will go ahead and inflict upon Iowa's youth. It is under current Iowa law, no parent is required to affirm their child's gender identity or propose a treatment plan for the same. Foster parents, this was something that was brought up during the subcommittee. While I'm not unsympathetic to the needs of trying to get more kids into more homes, I think we need to talk a little bit more about what that actually entails. Homeless and housing instability among LGBTQ youth is higher than their cisgender peers across the boards. 38% of trans girls and women report being homeless, 39% of trans boys, and 35% of non-binary students or youth, compared to 23% of cisgender youth. So you have an elevated risk of homelessness and displacement by virtue of having an LGBTQ identity. 16% of those queer youth report that they
to that same identity. When you talk about placing foster kids
with one, potentially you are taking them from one tragic environment and placing them in another tragic environment or another difficult environment, going from one home that doesn't affirm them to another home that doesn't affirm them. That would increases the likelihood and risk of that harm to that child and additional churning through the foster care system. Additionally, sections B, lines 12 through 14, basically establish and legalize and protect conversion therapy. Conversion therapy is a roundly discredited therapy that no major medical association, no major therapeutical association will go ahead and support. And let me kind of tell you a little bit about what conversion therapy entails. It entails negative reinforcement, including but not limited to humiliation, verbal abuse, limiting or withholding food, social and physical isolation, electroshock therapy, excessive mental labor, and in some cases, children are sent overseas so that way the authorities in their home states have no ability to oversee child abuse in this manner. These things will be inflicted upon kids in the name of making them quote unquote straight. One second here. The fact is that child abuse is already difficult to detect under current law. In many cases, child abuse goes on for years before it is ever reported to the proper authority. If these limitations are codified in Iowa law, it puts an additional barrier from being able to report child abuse in a timely manner, because people can simply say that they're affirming or trying to protect their child's gender identity, leading to prolonged abuse before the authorities are even able to step in under current Iowa law. And I would also point out this bill will not be limited to trans kids. This will be inflicted upon the nation's boys and young men as well, because young boys are often instructed, guided on their own gender identity at the back of a hand or the flick of a belt in order to determine or drive out anything that might be perceived as feminine or female, regardless of whether or not they identify as such. And I would like to, just as a side note, mention, some of you may know this, in 2011 I wrote a book entitled The Butterfly and the Flame. I dedicated that book to those people who had been lost their lives due to violence. One of the people who has lost their lives is a young boy by the name of Ronnie Paris Jr. He was 4 years old. He was beaten by his father to death because he didn't want his father, or he didn't want his son to grow up gay, or didn't want him to be feminine. He would be an adult now today if he was if he would be an adult now today. That perception of that fear that causes parents to abuse their children on the grounds of being gay or being trans does not limit that to kids who are gay or trans. So, in closing, what I will say is that this bill is being inked with the tears and the blood of the next generation. I would vote no today. I encourage my caucus to vote no, and I encourage everybody in this body here to vote no today. Thank you.
Is there any further discussion? Representative Wickendall, I would mention, and you may know about it, but Senate File 473 that I hope we get to the floor this year actually directs the Department of Health and Human Services that they have to place children, or they should be placing children consistent with their values. So I don't know if you've seen that bill or if you recall it, but we can also have a discussion about that in terms of maybe trying to provide some protections regarding what you're talking about. Thank you. At this time, the chair recognizes Representative Dunlop for closing remarks on House Study Bill 669.
Thank you, Mr. Chairman. House Study Bill 669 does not mention, does not authorize or protect conversion therapy. Neither does current Iowa law. The bill simply protects parents, foster parents, and adoptive parents from being investigated or punished by the state, as is happening in states like Ohio, Illinois, California, for being punished for raising a child consistent with their biological sex, included using accurate pronouns, declining experimental medical interventions, or pursuing therapy aimed at helping the child accept biological reality. In many ways, the raising of conversion therapy seems as a smear in one sense and is deliberate rhetorical overreach. This bill is about preventing the state from treating biological realism as child abuse. Regarding the implementation concerns, we already know that foster placement and adoption placement do take in consideration and are handled case by DHS. This doesn't create chaos. It prevents ideological disqualifications that are currently reducing the foster parent pool. This bill was deliberately written to protect children from irreversible medical harm and to stop the weaponization of child welfare against parents who reject gender ideology. Protecting biological reality is not bigotry, it's a common sense child protection. Concludes my remarks, and I move the bill, Mr. Chair.
Representative Dunlop moves House Study Bill 669. Clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Representative Wilburn.
No?
Representative Vigniski.
No.
Representative Dunwell.
Aye.
Representative Fett.
Aye.
Representative Gustav.
Aye.
Representative Nordman. Representative Olson. Representative Ramirez. Representative Shipley. Representative Srinivas. Representative Stone.
Aye.
Representative M. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Wessel Chriselle.
No.
Representative Wheeler. Representative Wickendall. Representative Williams. Representative J. Wills. With a vote of 14 ayes to 7 nays, passes.
The vote of 14 to 7, House Study Bill 669 will move to the floor as a committee bill. The chair recognizes Representative Fett for opening remarks on House Study Bill 632.
Thank you, Mr. Chair. There is an amendment.
There is an amendment. Chair recognizes Representative Fett for opening remarks on Amendment 2401.
Thank you, Mr. Chair. The amendment is a strike after amendment. It provides clarifying language to direct the Supreme Court to amend Iowa Rules of Criminal Procedure to clarify that the absence of recent dangerous acts cannot by itself determine whether a defendant acquitted by reason of insanity poses a risk. Under current law, if a person who has been found not mentally competent to stand trial shows that they are not a danger to themselves or others for a set period of time, they can be released. The new standards proposed in the amendment would now require consideration of the original offense, behavioral history, psychiatric history, current mental status, substance use disorder history, environmental influences, and expert testimony and risk assessment reports. The amendment explicitly states that the lack of recent dangerous acts cannot be used as a sole basis for deciding whether an insanity acquitted defendant is currently dangerous. Those are my opening remarks.
Is there discussion on Amendment 2401? Chair recognizes Representative Wickendall. Okay, no problem. Any other discussion? Representative Fett moves Amendment 2401 short form. All those in favor signify by saying aye. Aye. All those opposed? The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House Study Bill 632 as amended. Is there further discussion? The chair recognizes Representative Wickendall.
Thank you, Mr. Chair. I had the pleasure of sitting on this subcommittee. Generally speaking, I think these are pretty broad and straightforward bill. The only kind of comments to the contrary received just a little bit back from the judicial branch, feeling that we're kind of intruding upon the separation of state or separation of powers, and that they do most of these things anyway. That being said, the bill I think is pretty straightforward, and I'm a yes vote on it.
Thank you. Any further discussion? Seeing none, the chair recognizes Representative Fett for closing remarks on House Study Bill 632 as amended.
Thank you, Mr. Chair. The bill, again, House File 632, it closes the gap, so it ensures that we are looking at the full picture. So decisions about release or continued commitment are based on real risk, not just the absence of recent acts. I move the bill.
Representative Fett moves House Study Bill 632 as amended. The clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Aye. Representative Wilburn.
Aye.
Representative Bigniski. Aye. Representative Dunwell.
Aye.
Representative Fett. Aye. Representative Gustav. Aye. Representative Nordman. Aye. Representative Olson. Aye. Representative Ramirez. Representative Shipley. Aye. Representative Srinivas. Aye. Representative Stone. Aye. Representative M. Thompson. Aye. Representative C. Thompson. Aye. Representative Watkins. Aye. Representative Wessel-Christel. Aye. Representative Wheeler. Aye. Representative Wickendall. Aye. Representative Williams. Aye. Representative J. Wells. Aye. With a vote of 21 ayes and 0 nays, passes.
House Study Bill 632 by unanimous vote passes, and we'll move to the floor as a committee bill. The chair recognizes Representative Gustav for opening remarks on House Study Bill 161.
Thank you, Mr. Chairman. House Study Bill 161 is a pretty simple amendment to the durable power of attorney for healthcare statute. It revises the current law. It revises and clarifies the current responsibilities and current law. The authority of attorney in fact under durable power of attorney for healthcare requires them to give preference to the desires of the principal stated in the actual durable power of attorney and in life-sustaining procedures, declarations, or is made known directly to them. And it removes prior language about interpreting declarations related to hydration and nutrition withdrawal, and clarifies the verbal or the written statements. And the gist of this is that in the end, we're going to get medical care professionals out of the middle of fighting with family members about what mom or dad, for example, intended for their end-of-life treatments, and make sure that the person who has that power of attorney is indeed in charge of those decisions. There is an amendment.
There is an amendment. The chair recognizes Representative Gustav for opening remarks on Amendment 2362.
Yes, if you're looking at the bill itself, the amendment reverses the changes that are in lines 4 and 5, and it also changes line 1 to make sure that we're referring to the 2026 code instead of the 2025 code. And that's consistent. The lines 4 and 5 changes are consistent with the intent of the bill, which this will keep that the agent has a duty to act in accordance with the directives of the
Is there discussion on the amendment? Chair recognizes Representative Srinivasan.
Thank you, Mr. Chair. I want to thank Representative Gustav for working with us closely. This is an issue in the healthcare field where I've seen it almost every time I work in the hospital where we struggle because we want to make sure that we respect what the patient really wanted. And sometimes that is obscured because not everybody has had those discussions clearly with family. So I want to thank Representative Gustav for helping fix this amendment here that helps with the clarification of this issue and for working with us to get that done right. So thank you, and I support this.
Thank you. Any further discussion? Seeing none, Representative Gustav moves Amendment 2362, short form. All those in favor signify by saying aye. Aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House Study Bill 161 as amended. Is there any further discussion? Seeing none, Representative Gustav moves House Study Bill 161 as amended. The clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Representative Wilburn.
Aye.
Representative Magniski. Representative Dunwell. Representative Fett. Representative Gustav. Representative Nordman. Representative Olson. Representative Ramirez. Representative Shipley. Representative Srinivas. Representative Stone. Representative M. Thompson. Representative C. Thompson. Representative Watkins. Representative Wessel Chrisell. Representative Wheeler. Representative Wickendall. Representative Williams. Representative J. Wills. With a unanimous vote, 21 ayes and 0 nays, passes.
House File 1011, by unanimous vote, will move to the floor as a committee bill as amended. The chair, that was House Study Bill 161 as amended, will move to the floor as a committee bill. I got ahead of myself. Chair recognizes Representative Mark Thompson for opening remarks on House File 1011.
Thank you, Mr. Chairman. There is an amendment.
There is an amendment. The chair recognizes Representative Thompson for opening remarks on Amendment 2323.
This is a strike-after amendment from the bill introduced last year in which remittances from funds sent overseas by those not paying income taxes would fund the organization. This bill eliminates that portion. It establishes regional human trafficking centers which include investigators, prosecutors, and victim care advocates. Trafficking is our issue, not mine. I'm perhaps the one who mentions it the most, but after speaking with many of you, I'm aware you are rather astounded that our state has not done more. This legislation seeks to rectify by taking a bold step in proactively addressing an issue some avoid, but no one can deny. It is ours because we have a scourge that has not been effectively countered, and without a focused effort, it will continue to quietly thrive in the recesses of our society. Our current effort against human trafficking is well-intended, but under-resourced. It's one of the most complex crimes since both perpetrator and the victim seek anonymity. The perp for fear of conviction and the victim due to intimidation, humiliation, and gut-wrenching fear, which often leads to an even more wicked version of Stockholm Syndrome. The victim is compelled to normalize and rationalize his or her vile treatment. I've observed this firsthand this past summer when my wife and I sheltered a victim and her baby in our home. Trafficking involves both labor and sex. I first became of labor trafficking in my own county of Wright, where Frank DeCoster was exploiting immigrants who were recruited under false pretenses and often without permission to enter our country to get a better life, cleaning chicken houses for virtually nothing while living in squalid conditions. I spent over 20 years in counterterrorism overseas, responding to terrorist bombings, returning indicted terrorists from overseas to our court system, and recovering hostages by negotiations or any means necessary. When I look through the lens of human trafficking, I see a crime much more insidious. Terrorists and other violent criminals conduct their operations, then run and hide away. Traffickers, both buyers and sellers, live among us while silencing their victims by any means necessary. They live among us because they feel safe doing so. This bill seeks to change that behavior by increasing the likelihood they will pay a heavy price. Another reason this scum feels safe among us is because of the misguided perception the traffickers, and particularly the buyers, are dirty old men. Perpetrators, both buyers and sellers, are just as likely to be professionals and wearing a suit to work as they are a demented old man. Women are also often involved in the grooming and trafficking. Humboldt had a seed corn salesman and 2 females convicted in federal court in 2012 for trafficking girls from northwest Iowa to the Twin Cities. In the movie Grid Shock, one of the victims told of being taken to a lakeside palatial house where she was repeatedly violated throughout the night. Another told of a buyer who picked her up in the car with child seats in the back seat. Again, illustrating we are not dealing with people on the fringe of society. We have had arrests in Iowa, but not nearly enough in light of its prevalence. We have a task forces which convene when the right people are involved. I use the term right people for a reason, which I'll explain later. We do not have an effective rapid response capability. I'll illustrate with a point taken last summer. I get a text at 2 a.m. saying an individual, a friend of mine, witnessed going into a Casey's at 2 a.m. getting cold medication. He sees a adolescent girl dressed provocatively, we'll leave it at that, with the guy, won't let her eyes raise from the floor, won't do anything but stick close to the guy she's with. The friend of mine witnessed them get into another car outside in the parking lot with 2 other men, got the license plate, got the make and model, called it into 911. I checked with our law enforcement friends. There's no process to make sure somebody like that is tracked immediately along the interstate, in this case, near Dow's, Iowa. So the likelihood of that child being trafficked up or down I-35 that night was highly likely. We have had ample chances to be informed of human trafficking's existence if we only take the time. The movie Grid Shock, which I referenced before, brings this heinous crime to Iowa. All 3 of the young women in the documentary were Iowans. Their backgrounds were very different, but they all ended up in the same dark place, further illustrating the point that sex trafficking, unlike labor trafficking, spans all social and ethnic lines. The PBS documentary Rape in the Fields highlights labor trafficking in my county of Wright at the 20-minute mark. The follow-on documentary Trafficked in America provides an update. It aptly describes that minorities are the principal victims. Last year in my rural district, I received a call from a constituent asking why it was that 2 young girls were taken out of their home and placed in foster care because of their mother was alleged to have trafficked them to adult males in the region. And they were in foster care, and the mother was walking free. I spoke with HHS and law enforcement, and then law enforcement got engaged. And she was eventually arrested and charged with a Class A human trafficking charge and currently resides in the Dallas County Jail. I'm glad she's in custody and will face justice, but chagrined that it took a legislator to prompt it. The composition of this team is intentional because it highlights their individual and collective skills. Metaphorically, it's a 3-legged stool, which stays balanced when all 3 legs work together. Because of the skills are rare, building this team will take time. First, the investigators. Because the victims are so severely traumatized, investigators must have the interpersonal skills, training, and patience to approach victims when they are ready, after they've been rescued. That discussion needs to be based on the victim's status, not a specific timeline. In a similar fashion, the prosecutors must have the temperament and the training to develop a rapport with the victim to help them in the prosecution. Lastly, the victim's care personnel. Currently, there are several privately funded facilities in Iowa. Investigators and prosecutors are reliant on these professionals to determine when and sometimes if the victims are prepared to share their dark past, eventually and ideally in front of a jury. The ultimate goal is to turn victims into survivors. From my experience, I cannot say enough about the people who operate these facilities and the near miraculous impact they have had on those who need them most. Seldom are buyers found or prosecuted. This team would seek to improve that current reality. We hear a lot about the Epstein list, and we are aghast that it has not been fully reported. We have that same vile behavior here, enslaving another human being for one's own filthy gratification. Here, we likely will not impact the Epstein story, but we will, with this bill, have a chance to fulfill our duty and our responsibility to help those hidden within the crevices of our society that we would rather not see. Those end my comments, Mr. Chairman.
Is there discussion? Chair recognizes Representative Srinivas.
Thank you, Mr. Chair. I've had the opportunity to work with Representative Thompson on this bill for the last year when he first introduced it, and I thought it was a great idea then, and it's even better now. I want to thank Representative Thompson for working with me. My big concern about the bill has been addressed with the strike-through, and now this strike-through has actually made it an even more comprehensive effort to address this problem that we should all be invested in. So I want to urge my caucus to support both the strike-through and the bill today. Thank you.
Is there any further discussion? Chair recognizes Representative Thompson for closing remarks on House File 1011 as amended. Okay. I was so involved in Representative Thompson's remarks that did we pass the amendment already? Yeah. I apologize. I'm so into I got to tell you, I don't know if there's anything more important that we do than this issue. It's just so disturbing. So we need to move the amendment. Is there any further discussion on the amendment? If not, Representative Thompson moves Amendment 2323 short form. All those in favor signify by saying aye. Aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House File 1011 as amended. Is there further discussion? Seeing none, the chair recognizes Representative Thompson for closing remarks on House File 1011 as amended.
Mr. Chairman, I move the bill.
Representative Thompson moves House File 1011 as amended. The clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Aye. Representative Wilburn.
Aye.
Representative Bigniski. Aye. Representative Dunwell.
Aye.
Representative Fett. Aye. Representative Gustoff. Aye. Representative Nordman. Aye. Representative Olson. Aye. Representative Ramirez. Aye. Representative Shipley. Aye. Representative Srinivas. Aye. Representative Stone. Aye. Representative M. Thompson. Aye. Representative C. Thompson. Aye. Representative Watkins. Aye. Representative Wessel Chriselle. Aye. Representative Wheeler. Aye. Representative Wickendahl. Aye. Representative Williams. Aye. Representative J. Wells. Aye. With a unanimous vote of 21 ayes and 0 nays, passes.
House File 1011, by unanimous vote, will move to the floor as a committee bill. The chair recognizes Representative C. Thompson for opening remarks on House File 2174.
Thank you, Mr. Chairman. This bill directs the judicial branch to establish a task force to investigate statewide delivery of legal services to indigent people. I could go for a half an hour without stopping on this problem, but in order to be pithy, I will just leave it there. There is an amendment.
There is an amendment. The chair recognizes Representative Thompson for opening remarks on Amendment 2430.
This amendment adds a party to the proposed task force. It would be a person who has practiced law for less than 5 years.
Is there discussion on the amendment? Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. I think this is an excellent bill and an excellent amendment. As a young person myself, I think it's critical that we have younger attorneys that's represented in this task force or newer to the profession. So I am in support of the amendment.
Thank you, Representative Ramirez. Is there any further discussion on the amendment? Seeing none, Representative Thompson, you're recognized for closing remarks on Amendment 2430.
I move the amendment short form, please.
Representative Thompson moves the amendment short form. All those in favor signify by saying aye. Aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House File 2174 as amended. Is there any further discussion? Yes, Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. As I said before, this is an excellent initiative, an excellent bill. This will help our state work towards every Iowan receiving excellent representation, regardless of their income status. I recommend a strong yes for my caucus. Thank you.
Thank you. Is there any further discussion? Seeing none, Chair recognizes Representative Thompson for closing remarks on House File 2174 as amended.
Right now, to the shame of Iowa, we are not providing adequate legal representation to indigent persons. It's required under both the United States and the Iowa constitutions. This bill is a step in the direction of fixing that horrible problem, and I'd like to move the bill.
Representative Thompson moves House File 2174 as amended. The clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Representative Wilburn.
Aye.
Representative Vigniski. Representative Dunwell.
Aye.
Representative Fett. Representative Gustoff. Representative Nordman. Representative Olson. Representative Ramirez. Representative Shipley. Representative Srinivas. Representative Stone. Representative M. Thompson. Representative C. Thompson. Representative Watkins. Representative Wessel Chriselle. Representative Wheeler. Representative Wickendall. Representative Williams. Representative J. Wells. With a unanimous vote of 21 ayes and 0 nays, it passes.
House File 2174. With unanimous vote, we'll move to the floor as a committee bill. A couple of housekeeping items. When we adjourn, we'll be caucusing on House Study Bills 663 and House File 981. I would also mention that next Thursday, right? Next Thursday is our final funnel meeting. As is my tradition, I will provide pizza and pop. So our meeting's at 10:30. Don't eat. I don't want to carry a bunch of pizza back to my hotel room. So there'll be pizza in here for Democrats. You get it before you go to caucus. We'll have ours in here. So come hungry. Is there any further discussion to come before the committee?
Democrats will caucus, and thank you for the pizza head up before mentioned.
Seeing no further discussion, Representative Srinivas moves we rise. Have a great day.